People may feel an ethical responsibility to take care of sick or aging relatives. But is there a legal responsibility to take care of your family? We'll see whether there was a legal duty of care between siblings in Rex v. Smith, a 19th-century English law case. George Smith was a 40-year-old developmentally disabled adult. George had always been developmentally disabled, but in recent years, George had also become bedridden. When George's father died, his father's will dictated that George's siblings, William, Thomas, and Sarah, had to pay George a yearly stipend. However, the will didn't explicitly state that George's siblings had to provide care for George. William, Thomas, and Sarah kept George confined in a dark room that was covered in filth and didn't have any heating. George's siblings also deprived George of adequate food, water, and clothes. A magistrate visited the home and found George lying on a bed covered in a blanket and a coat. George's limbs had become contracted, so he was unable to stand or move. George was taken from the house and brought to an asylum. The Crown, referred to as Rex, the Latin name for the king, charged William, Thomas, and Sarah with assault, false imprisonment, and unlawful neglect. William, Thomas, and Sarah pleaded not guilty and argued that they hadn't committed an assault. Instead, William, Thomas, and Sarah claimed that there was only nonfeasance, or failure to act, which wasn't a crime, because there isn't a duty of care between siblings.